Hi, my name is Roger Davey, and this video today is about an EEOC mediation. I'm going to assume that the people watching this video already have an EEOC mediation that they've agreed to go to and that they're going to an EEOC mediation. And this video is how to prepare for it and what's going to happen at that EEOC mediation. I'll cover a little bit about how you get to mediation for those that haven't decided whether they want to go or not, or maybe even those that have agreed to go to mediation but maybe are having second thoughts. So we'll cover that briefly as well too. First thing you need to realize is that EEOC mediations are part of the EEOC process in an attempt for the EEOC to settle some cases and to move those cases off the system. What happens is when a case comes into the EEOC, they really separate it out into different categories. But one of the categories they separate them out into is a case that they think may have some merit. They're not sure, but they think it's a case that for whatever reason should go to mediation before they do an investigation. And if they do that, usually when you go in and you fill out the charge, the EEOC will ask you if you want to mediate. Usually give you a sheet of paper, ask you to fill it out, maybe with some mediation information as well too. I guess the first question people may have is should I say yes? And my answer is generally is yes, you should do that. You should fill it out, you should agree to go to mediation. You really have nothing to lose. If you don't settle at mediation, then the case goes back to the EEOC and it goes for investigation. Now, before a case can be mediated, just because you say yes doesn't mean it'll happen. Your employer has to say yes as well. And so if you say yes and then your employer says yes, then you end up going to mediation. Now, I'm going to assume for the purpose of this video that if you're going to the mediation, you're going by yourself, you don't have a lawyer. If you have a lawyer, then your lawyer certainly, a competent lawyer, will get you ready for the mediation, will talk to you about it, and generally will take care of all the details. In fact, the lawyer will usually do the talking for you. Now, I would always advise you that if you can get a lawyer to go to the mediation with you. In some cities, especially El Paso, Texas, where I'm a Texas board certified lawyer in labor and employment law. For the most part, lawyers in our city agree to do mediations on a contingency basis. That means we charge a percentage. We usually charge a smaller percentage to go to just to a mediation than we do to take on a whole case. But that'll vary from city to city and from lawyer to lawyer. But I can tell you as a general rule, you'll get more to mediation if you have a lawyer than if you don't have one. But if for whatever reason you don't have a lawyer, and a big percentage of people that go to mediation don't have lawyers, don't let that keep you from going to mediation. Mediation is a great chance for you to hear what the other side says, so you know what their case is. It also gives you a chance to settle your case and to move on. Now, we'll tell you because the mediation occurs early in the process, and neither the employer or you really have all the information. You haven't gone through discovery process, haven't taken depositions or traded interrogatories and any other things we do when the case is filed or a lawsuit's done. You don't have quite enough information, but still it's a good time to try to settle your case if you can early and get out. If the case settles, they usually settle for smaller amounts of money, or they settle for something non-monetarily, such as a job back, maybe a letter of recommendation, your employer won't fight your unemployment. But for whatever reason you decide to mediate, it's a good process to go through because even if you don't settle, you still get some information. Now, at the mediation, when you show up for the mediation, you'll have a mediator. Now, what is a mediator? A mediator is a neutral. They're a third party that is hired by the EEOC. Sometimes, in fact, usually they're an EEOC employee, but that's not always true. They can be outside mediators. Their job is to bring the parties together and to see if they can get a settlement. Now, what you need to understand about the mediator is that their job is to try to see if there's any place in between you and the employer where you can come to some resolution of the case and settle the case and basically get it off the docket of the EEOC to move that case out. Mediators are judged to a large degree by how many cases they settle. And that's something that you really should understand, because a mediator is someone who's not on your side, and they're not on the employer's side either. Their goal is to try to get the case settled. And you should understand that, because if you're under the false sense that they're there to help you somehow, then you can be lured into a settlement that may not be in your best interest. So just always remember that. I've had, for the most part, good mediators. We certainly have a good mediator in El Paso, Texas, but I have had some mediations with the EEOC, with some outside mediators, where the mediators, at least in my opinion, were not up to par for what I would want for a mediator. So they really vary a lot. And we'll talk a little about how to handle that situation. So the first thing that's going to happen is when you go to a mediation, it's going to be in a conference room. And what's going to happen is the mediator is going to bring you together. You're going to introduce the parties. And the first thing the mediator is going to tell you is that the mediation is confidential. And in fact, at the EEOC, they actually require you to sign some paperwork where you acknowledge that the mediation is confidential. So what does that mean by a confidential mediation? It's really pretty strong, especially in Texas. What it means is that whatever happens in the mediation stays at the mediation. It doesn't matter what anybody says. It doesn't matter if they admit liability. It doesn't matter what they say. That cannot be used against them outside of the mediation. So even if your employer were to admit liability and say they did something wrong, you're not going to be able to get that in front of a jury or be able to talk about that because you've agreed to keep whatever happens to the mediation confidential, and so is your employer. And it's a very strong confidentiality clause. Courts seem to universally uphold those, especially in Texas. I suspect most other states as well too. So always remember that mediation is confidential, and that's for a reason. That's so you can lay your cards on the table, both parties can, and see if there's a place where you can come together and meet. Now, before you go to your mediation, you know they always get a call from the mediator letting you know about the mediation. Sometimes they'll give you some information about it. They'll kind of cover what's going to happen with you, sometimes not. So the purpose of this video is to kind of guide you into what's going to happen. The first thing I will tell you, though, is before you go to the mediation, at some point in the mediation, you're going to get a chance to give your story of the case. And so I would advise you that before you go to the mediation, look at the charge you filed with the EEOC, read that very carefully, and come up with a short statement, 5-10 minutes at the most, to kind of cover why you believe you've been discriminated against for whatever reason you put in the charge, whether it's race, color, religion, gender, national origin, age, disability, or retaliation because you filed a claim for those things. You really need to make sure that you have a statement that you can be concise with, that's not personal, it doesn't attack the other side, that really lays out the facts of why you believe you've been discriminated against. It's not an easy thing to do. You need to do it, you need to practice it, you need to be ready for it because you're going to have a chance to tell the employer. And this may be your employer's first time to really get your story and for them to understand. I cannot emphasize enough how important it is for you to be professional, polite, and nice. The other side is judging you. If you come across as nasty, if you come across as hateful or bitter, that's going to show through and it's going to make it much more difficult for you to come to a resolution. So make sure that you practice that statement, that you know it by heart. It's okay to take notes with you at the mediation, but make sure you do that. The reason that's important is that when the mediation starts, good mediators will almost invariably turn to you and say, tell us about your case. That's your chance to give this statement. Now, here's where you really need to be careful. And that is that if anybody tries, and the mediator ought to tell the other side to let you finish, and the mediator lets you finish. But I've seen cases where sometimes the mediator will come in and actually try to start cross-examining you at that time, start asking you questions in front of the employer. I don't let mediators do that. I tell them up front if they try to do that, that's not the way I do mediations, and it's not the way I think you should do mediations either. I think you ought to tell the mediator, I'm happy to talk to you one-on-one, but I'm not here to give a deposition. I'm not here to be cross-examined. That's true of the mediator, and that's even more true of your employer. You don't have to let them sit there and cross-examine you, and I would highly encourage you not to do it. And if the mediator says, well, I've always done it that way, I do it that way, I would tell the mediator I'd like to talk to you outside. If the mediator for some reason doesn't want to, then you have the right to leave. And I would be strong about that. You don't have, this is a voluntary thing. It's not mandatory. Be polite, be nice about it. And in fact, you can tell the mediator that before you even go in, that that's how you plan to attend, that you don't want to be cross-examined in front of the other side, that you're happy to talk to the mediator one-on-one, but you're not there to be cross-examined either by the mediator or by the other side. And I can tell you, nearly all competent mediators will not do that. But every now and then you'll run into someone that does it. So anyway, at least that's my opinion. Other lawyers may differ. I know there's some mediators that differ, but that's something I feel very strongly about. You'll give your side of the story. Hopefully you've done a good job. You've been polite. You've been nice. You've been articulate. At that point, then it's your employer's side. This is really probably the most important part of a mediation. Because at this point, you need to really listen. Don't interrupt. Be courteous. Really listen to what your employer says. You'll learn a lot about your case. You'll learn a lot about why your employer thinks they're right and you're wrong. And sometimes you'll find out that you are wrong and they are right. Other times you'll find out that your employer is mistaken about something, and that's important too. I always take notes during that time period. I want you to know, in some jurisdictions and some mediators, they don't like you to take notes because they told you about the confidentiality. They don't want you taking it out of there. Some will let you take notes but ask you to turn them in at the end. But I think it's important that you keep good notes, or at least in your mind or on paper if you can, of what your employer said, and especially things that you think they're mistaken on. The mediation is not a time for you to argue with the other side. It's not a time, there's some things you're not going to agree on, but this is not the time or place for you to fight the case out. This is a time for you to listen and hear what they have to say. At that point, most of the time you'll have what's called a breakout session. You'll go to another room, or the employer will go to another room. The mediator will then come to you and will talk to you about settlement. In other words, what do you want? Give this some thought before you go to the mediation. You shouldn't be coming up with your thoughts of what a settlement is when you show up at the mediation. If you do that, if when you show up at the mediation that's the first time you've thought about settlement, it's going to make it a lot harder to settle your case. So a lot of people ask me, well, what should I settle for? It's hard to say because every case is different. It depends on the facts of your case. Figures out what your lost wages are. How much money did you lose? Are you getting unemployment? At least in Texas, the employer generally used to offset unemployment. So what are your back wages? What are your future wages? You know, if you've got another job where you're making more money, you got it right away, your damages won't be as great as if you lost a high-paying job and the odds of you finding another job are not very good. So your lost wages is certainly a driving point. The facts of your case and how you felt and the mental anguish you suffered. Did you go to a psychologist, a psychiatrist? I mean, we all understand that termination is a very traumatic event. And certainly you want to be able to convey that during your opening statement about how it's affected your life. You want to be able to be articulate about that so that the other side understands that a jury may give you money for your mental anguish. So go through that and decide what your case is worth. I will tell you this, and I think everybody would generally agree. Nobody gets everything they want in a mediation. Everybody has to compromise. And I will tell you this, if you're not willing to compromise, then mediation is going to be a waste of time for you. Because generally most people walk out of mediations a little unhappy. They didn't get everything they wanted. So be ready to compromise. Finally, at the end of the day, if you reach a settlement with the other side, you'll be asked to sign a settlement agreement. I want to make sure that you understand this. Once you sign that settlement agreement, for the most part, you're done. Your case is over. The EEOC will dismiss your case, and that's the end of your case. And that's it. So you need to understand that. You know, whether they're going to reinstate you to your job, whether they agree to pay you money, or whatever kind of solution that you came up with. Once you settle, your case is over. And just some advice, once you settle, don't look back on it. Don't sit there and think, oh, I shouldn't have done it. What should I not done? It's very easy, I find, for clients to do that. But once you settle, move on with your life the best you can and go forward. Because once you settle, it's over. But don't settle unless you're really sure you want to settle. Don't be bullied into settlement that you don't want. Don't be bullied into something that you don't think is fair. Yes, compromise, but don't sell yourself out either. Thank you very much. My name is Roger Davey. I'm a board-certified labor and employment lawyer in El Paso, Texas. You can go to my website, www.rogerdavey.com, for more information. Thank you.